Day 3 of the Ontario government's constitutional reference of the federal carbon tax just wrapped up at Osgoode Hall, meaning this chapter of the legal saga has almost come to an end. Now, part of what happened Wednesday in this court was a series of interveners, third-party groups that aren't directly parties to this litigation, were speaking up about what their organizations feel are the critical issues here. And there was a wide range of voices, from the Assembly of First Nations to the Canadian Taxpayers Federation to the United Conservative Party, which between the time it filed its factum and the time it argued it, had actually won a majority government in the Alberta election. What was fascinating about the interventions, though, is that some of them were actually putting forth arguments that even the federal government wasn't putting forward to defend its position. Namely, that carbon taxing is actually something that addresses a critical national emergency in Canada. This idea was advanced by a few interveners, most notably the David Suzuki Foundation and the Intergenerational Climate Coalition. Both said that carbon pricing, and specifically the federal government's greenhouse gas pollution pricing scheme, could indeed qualify as being able to subvert the division of powers in the Constitution because it addresses climate change, which they say is a national emergency. And the Constitution says that Parliament can, when responding to a, quote, grave emergency, unquote, deal with legislation that doesn't respect the traditional and constitutional boundaries between what the federal government is responsible for doing and what the provincial government is responsible for doing. But in actuality, with how much alarmism was put forward by both these organizations, it's a wonder we even survived to the end of the day. The Intergenerational Climate Coalition lawyer actually was invoking Helen Lovejoy from The Simpsons when he told people,
"I am asking the court to think about the children."
Oh, won't somebody please think of the children?
And the Suzuki Foundation's argument was not much better. They eased into it by basically saying we're all going to die unless we deal with this fight. Now, that's my paraphrase, but I'm not really changing all that much about the substance of what was argued. But here's the hitch in this. The federal government never actually brought up emergency provisions when it was putting forward this legislation. Similarly, when the federal government was laying its argument out to the Court of Appeal, it never talked about emergency powers. It was only after the David Suzuki Foundation, in its intervention filing, said, we think there's a case to be made for emergency powers here, that the federal government issued another document, what's called a reply factum, saying that if the court finds that yes, in fact, there is an emergency here, we will argue those grounds instead. So the federal government basically says, this isn't our primary argument, but you know what, if it's a way that gets us to the finish line, we'll take it, we'll embrace it. There was a little bit of pushback on that from one of the judges in particular, Justice McPherson, who said, I'm not convinced the interveners can argue this provision when it isn't even part of the federal government's argument, although one of the interveners actually pushed back against that and said, well, actually, you're allowed to take into account any arguments wherever the source of them is. But it showed how much of a hyper-reaction there is from a lot of the environmental groups in Canada, where they believe that the government should be able to do anything and everything, even if it means that there is not a traditional respect for the way the Constitution is supposed to work. And I have to truly invoke the words of the lawyer for the Attorney General of Saskatchewan, who I think very aptly said,
"The line between policy and politics is pretty blurry, and that it would be possible for the federal government to use its taxing power to apply taxes in some provinces but not others for purely political reasons. And it can't escape notice that in this case, the carbon tax only applies in 4 provinces with conservative governments. As I said in the Saskatchewan Court of Appeal with respect to this point, you need to slam the door on that Pandora's box forever. Obviously, Canada's concern is that this act is required because without the legislation, provinces can opt out of any national plan to address climate change, and that will undermine the efforts of others. In my submission, there's a one-word response to that argument, and it's federalism. We live in a federal state where both the federal and provincial governments have jurisdiction over pollution, including greenhouse gas emissions, within their respective powers. The POG power is not a big stick that can be used by the federal government to force provinces to adopt particular policies or to adopt uniform standards with respect to matters within provincial jurisdiction. no matter how important the issue is. Justices, it's my submission that you don't need to throw out the Constitution in this case in order to save the planet.
I would argue that Justin Trudeau and his government and their lawyers need to pay very close attention to that. The trial's almost over. The coverage continues. For True North, I'm Andrew Lawton.